So once you know that you've pulled apart the case, you've analyzed the case, you have good facts and bad facts, possibly you've ranked the really most important facts and you've ranked the facts that could impact you the most on the other side. You've pulled forward now what's going to be your theme. How do you win? How are you going to be successful? How are you going to prevail in this case? In some of the ways we talked about. And then you're trying on these different book covers. Another popular analogy is it's the movie trailer. What clips do you kind of put together in an action packed persuasive 20 seconds to say here's why we win. So you're trying out movie trailers, you're trying out book covers to be the thematic language. Now it's actually you got to plan out. And a lot of mock trial, it's planned out for you. You don't get to call every witness in the world. You get to call the two that were identified for your side, or maybe three or four. You don't get to put in every exhibit in the world and go do an investigation. It's the exhibits that are contained in the packet. So some of that strategy, some of that organization is done for you. But think about how many questions are left unanswered that are for you to plan out. Right? Which witness will you call first if you have a choice between 2, 3, or 4? What's the batting order of those witnesses? Why would the batting order matter? Who should the jury hear from first? Who should they hear from next? And maybe who should they hear from last before it is the other side's case, or we're getting ready for closing argument? You should think very deliberately about those. And then within each witness, excuse me, who's the one that we put the exhibits through, who has knowledge and personal knowledge of those exhibits and can speak to them and say what they are, who which parts of the testimony from their depositions, which parts are going to be the most relevant that we put on, what's a truly good fact that we're going to pull through, and what's something that doesn't necessarily help us that we don't need to just restate because it's trial and someone asked them before. So remember, the trial packet is full of all kinds of red herrings. It's full of all sorts of information that does not contribute. So you can't just take a statement to an investigator. You can't just take a deposition and say, well, here's the information they got out before. I'll just ask direct examination questions, who, what, where, when, why, describe, explain type questions, and go for it. No, not all that stuff matters. Not all that stuff was good facts for you. Focus on the stuff that matters. So you're planning out this strategy. What is the testimony I want from witnesses? What exhibits are going to come from witnesses? And how does it add up? It can look like a chart like this. So this is a really crude chart. I did something like this, or most trial attorneys do something like this, but what are the things you want to say? What are the arguments you want to make that are probably going to be in line with your theory? So if I go back to that robbery case and I am representing the prosecution, argument one is just going to be, did this defendant sort of see and know about that opportunity of the door being open and the store being unattended? Maybe that's argument one. I just want to talk that he knew it. That is the opportunity. I want to talk about the opportunity. So I have a couple witnesses. I'm calling ABC at trial. What are the specific pieces of testimony? What are the responses to my questions that are going to come out of their mouth that are going to add up and be filed under that argument that I'm going to pull together at the end? You got to remember, if we're planning forward for closing argument, trial is disjointed. I don't get to just put the stuff together that I want to go together. I have to put a whole witness on, and then I have to put a whole nother witness on. And between calling witness A and witness B, the other side gets to ask questions and other things that they care about and the facts that are good for their case. So it's disjointed in the way it came out. It's unorganized in the way it came out. This is your opportunity to pull it together. I want you to consider testimony from witness A, exhibit 4 that you heard from B, exhibit 8 that you heard through witness C, something else that witness C said, because it aligns with my argument. There was an opportunity and he knew about it. Argument 2 could be, and when he was in the store, he did it when he was in that store, he committed a robbery, he committed a crime. He was in there for the wrong reasons. I'll have whole separate pieces of testimony, maybe from these same witnesses, maybe from different witnesses. I might have different exhibits. So that way I can separate out from my closing or my colleague's closing. Here's the stuff that aligns with my one argument about that he knew there was an opportunity, and the other stuff aligns with when he took that opportunity, he did so with a bad intent. He did so with a criminal intent. So there's some type of strategy, there's some type of organization. Now, it may matter that A comes before B in your witness lineup, depending on what this testimony and what exhibits you expect to pull through each. But you can't go to trial not knowing this. You can't go to trial not knowing the testimony you expect to get from A. And the mistake that people new to the practice of law, new to mock trial, is they say, well, here's a question that an investigator on the scene in this car accident case, in this civil case, here's all the questions they asked one of the drivers. So I have a direct examination of that driver at trial. I'm going to ask all the same questions. Per se, doing it wrong. You cannot possibly be doing it right. The purpose of those questions that an investigator was asking at the scene was to try to figure out what happened. You already know what happened. You know the good facts and bad facts of the case. You know how you're going to win. You can't possibly ask all the sort of discovery type questions that they were asking before, just the information gathering questions. You know what happened. Ask what goes to your side of the case. Ask which aligned with your theme of the case. Put in the good facts and put emphasis on the good facts. If you have something really high on your chart, that's a really good fact. It might be something that you cover with A, B, and C if they have personal knowledge over it. So there could be certain repetitive nature to your presentation because it underscores and highlights what's really important. And you could say, hey, the idea that the door was open and the idea that the defendant saw it, you didn't hear that from one person. You heard that from witness A, you heard that from witness B, you heard that from witness C. You even heard that in cross-examination of the defendant himself. So we can highlight what happened during trial. Strategically organize pieces of testimony, exhibits at trial, other evidence that might be as it goes to the arguments you want to make in closing, in line with your theory and as presented through your theme. Okay, we forecasted this one, the oppose your opponent's theme. So they're going to have a reason why they win. You might not know. Sometimes if you're the prosecutor in a case, I don't know what their defense is going to be. One defense could always be in a criminal case, the prosecution hasn't met its burden. They haven't proved beyond a reasonable doubt that these elements were committed. So that could be one theory. Another theory, as we suggested, could be, yes, someone robbed that store. It just wasn't this defendant. You haven't proved beyond a reasonable doubt that it's this person. And it's also going to be, you hear their theme. Their theme could be the defendant's a really nice guy and an upstanding member of the community. Well, knowing what it is, when you hear it, thinking about the rest of the trial, those good facts, bad facts, your own theory, your own theme, how do you oppose it? Or is it something you just save for closing? Throughout this trial, you've heard from the defense that he's a community guy and someone that contributes to his community, and he's a really nice guy. Could he, in fact, be a really nice guy and a community person that committed this crime on this day? Let's look at the facts. So I can take on the other person's theme. I always encourage mock trial teams to focus heavily on their theory, their theme. It's an 80-20 rule or a 90-10 rule. And when I say that, that means I want 80% or 90% of you focusing on the good stuff for you. Don't worry about answering to every little thing that's out there. Don't worry about responding to every little thing that the other side says. Focus on why you win. Focus on the good stuff for you. That other 10%, that other 20% is what you can devote. And sometimes it might be reserved all the way to the end of trial to closing. One stinger comment like, who's seizing the opportunity here? Who saw his chance? The prosecutor sitting right over there who brought this case and wanted to put an end to it even though they didn't have the right guy. One statement you might be able to oppose their theme. But just like any adversarial process, just like any competitive environment, spend some time thinking about what the other side's going to say. And sometimes mock trial itself is helpful for this because you as a team might be looking at both sides of the case, so you know how you're looking at it when you're on the other side, your opponent's side. But also there could be another team that's part of your same mock trial program that they're on the defense side, we're on the prosecution side. You should share. You should say, what do you have to say about that? And what do you say about that? And what arguments do you make as to this good fact for us? Or what arguments do you make as it relates to that bad fact for you? And you workshop essentially your opponents, but think about it in an 80-20. Think about it as a 90-10. When I talk about an opening to start out the case, focus on your case. Nobody wants to hear in the beginning how you're talking about why someone else can't do something. No, just focus on your case in the beginning, and then you address it throughout trial. That's mainly what cross-examination is about. When you get to closing, it can shift to I can devote some of my time to saying, you heard them say this. Here's some other evidence that refutes that. Main thing you want to do is those bad facts that you identify in the beginning of this case, those bad facts for you, If believed, you lose. So you have to be able to call them into question. You have to have opposing arguments and counter arguments to those bad facts. That's why you analyze the case in the first place. If they came out at trial, then you got to have counter arguments or credibility arguments to make as to why they shouldn't be believed.